Ms. Robertson, assistant to the Solicitor General of the United States, offered her arguments in support of vacating the lower court decision.
Mr. Chief Justice, and may it please the Court, the Court of Appeals applied a different and more difficult standard to petitioner because it considered her a member of the majority. But Title VII draws no distinctions between plaintiffs based on their race, religion, sex, or other protected characteristic. That alone is reason to vacate the decision below, but the Sixth Circuit's test would have been wrong if applied even-handedly.
Ms. Robertson gets right to the point. While the Court of Appeals applied a standard, it was not based on the law, but on their own apparent desire to discriminate against what they see as the majority. That alone should be enough to vacate their decision. But Ms. Robertson goes further, claiming that even if the court had applied the test even-handedly, it would have been wrong.
The court required evidence, reason to suspect an employer usually discriminates against a group, that the statute does not, and it required more evidence to make out a prima facie case than this court has held as necessary, including in McDonnell Douglas itself. That heightened standard risks screening out cases with merit and complicates litigation by focusing on whether to shift a burden of production that Ohio had already met in this case. The court should vacate and remand for the Court of Appeals to apply the proper standards in the first instance, including to consider Ohio's alternative arguments for why summary judgment might still be proper. I welcome the court's questions.
The goal of the court should not be to screen out cases which may have merit, especially because of some protected class. Now, in response to a question from Justice Jackson, Ms. Robertson brings up an interesting point. Does a lack of evidence of discrimination against a group mean that there cannot be discrimination against an individual?
So what the Sixth Circuit did here, for instance, by asking for reason to think that an employer usually discriminates against a group, requires evidence that a plaintiff wouldn't need to establish liability under the statute, because, of course, even if an employer generally treats a group well, if a plaintiff has evidence that the employer discriminated against her, she should be able to proceed.
Later, in response to a question from Justice Alito, Ms. Robertson pointed out how she believes the Sixth Circuit got it wrong.
I think it's important to distinguish between two ways that a court might take race into account. The first is the way that the Sixth Circuit did, which is tell me your race and I will tell you how much evidence you need to produce, or I'll apply in a different standard. That would be wrong at any stage in the proceeding.
Okay.
That's not to say that race is irrelevant in a race discrimination case or that sex is irrelevant in a sex discrimination case. Second, courts can consider a plaintiff's identity to help them draw inferences from the evidence in the record. So comments that look neutral in a vacuum might take on a different valence when directed at a certain group.
In other words, it's not that race doesn't matter in discrimination cases, but that your burden of proof should not be based on race, sex, or any other grouping.